This isn't the most serious crimes. You were charged with a felony. However, through facts whittling themselves down, really a misdemeanor. You're not a threat to the community, at least this community, as far as we know. I think that the agreement is appropriate, so I'm going to adopt it. I'm sentencing you to 32 days of jail, time served, and $200 DNA surcharge per count. I'm waiving the rest of the court costs and fees. If you fail to make the payments and you fail to pay this off, not only will the court enter a civil judgment against you, but the court will issue a warrant and you could sit up to 6 months in jail. Mr. Feliski, can you hear me?
Yes, Your Honor. Good afternoon.
Good afternoon. Ms. Diver has stated that she is okay with you appearing by telephone instead of by video conferencing. And if she needs to speak with you, we will make arrangements so that she can speak with you, and we will adjourn the hearing, okay?
Understood, Your Honor. Thank you. To just continue where I left off, the parties have reached an agreement to resolve in this matter. Ms. Diver has agreed to plead to counts 2 and 3 of the complaint, which would be obstruction of law enforcement and possession of drug paraphernalia, with count 1 being dismissed and read in. The parties will be making a joint recommendation for time served and court costs on each count to run concurrent. I have here applicable credit from when she was brought in on this case in March 6th of 2026 and was then transferred out of Burnett County, out of custody here on April 6th, of 2026. So she would have 32 days of credit. I have gone over a waiver of preliminary hearing form with Ms. Diver along with a plea questionnaire. Those were both reviewed by phone. I reviewed them line for line and word for word. And Ms. Diver indicated to me she understood both documents and that were she physically able to, she would sign and assent to both. I filed those as documents 17 and 18 in the case file.
Thank you, Mr. Feliski. A very good summary. Ms. Diver, do you understand what a preliminary hearing is?
Yes.
And your attorney went over that document with you very thoroughly?
Yes, he did.
And you authorized him to do an electronic signature?
Yes.
And you understand that once you give up the right to a preliminary hearing, it's forever? You cannot get it back?
Yes, ma'am.
Has anyone made any threats or promises to you for you to waive the right to a preliminary hearing?
No.
Okay, I will find that you're competent, you're freely, intelligently, and voluntarily waiving the right to a preliminary hearing. I find probable cause and I bind the matter over. Mr. Schmidt will be filing an information. At this time, not guilty pleas, but Ms. Diver, you also went over a plea questionnaire waiver of rights form with your attorney. Is that correct?
Yes.
And he went over it with you, as he said, word for word, correct?
Yes. Yes, he did.
And you gave him authority to electronically sign for you, is that correct?
Yes.
And you are pleading guilty to obstructing an officer and possession of drug paraphernalia, correct?
Yes.
No drugs, no alcohol, no mental illnesses or disorders, correct?
Yep.
And your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt and the maximum penalties, correct?
Yes.
And he went over your constitutional rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
You understand them fully?
Yes.
You understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand the state would have to prove on or around March 6, 2026 in Burnett County, Wisconsin, you knowingly obstructed an officer while the officer was doing an act in an official capacity and with lawful authority by giving a false name and birth date. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both. Do you understand that?
Yes.
You understand with possession of drug paraphernalia, the state would have to prove the same date, time, and place that you possessed knowingly with the primary intent to use a pipe to inhale a controlled substance. Do you understand what the state would have to prove?
Yes.
You understand maximum possible penalty could be a fine of up to $500 or 30 days of incarceration or both.
Yes.
You also understand that I'm not bound to follow the agreement. Being said, I could sentence you to the maximum possible penalty.
Yes.
You still wish to proceed and enter guilty pleas?
Yes.
Did your attorney go over the alleged facts with you in the criminal complaint?
Yes.
For the most part, are they accurate and true?
Yes.
Are you pleading guilty to these offenses because you are guilty?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Ms. Diver, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing,
Yes.
and you are doing so voluntarily?
Yep.
Has your attorney represented you competently?
What? Yes, he is.
And he's answered all of your questions?
Yes.
Are you satisfied with his services?
Yep.
Any questions for the court or for your attorney before I proceed?
No.
As to count 2, obstructing an officer, how do you wish to plead?
Guilty.
As to count 3, possession of drug paraphernalia, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. The remaining count will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think that this disposition is appropriate. This is a person who was escaping a warrant from Minnesota, essentially, and then tried to lie to police in Wisconsin to avoid accountability for that and had some paraphernalia. I think if she's going to get treatment to deal with the paraphernalia, it should be in Minnesota. That's where she has connection to. I don't think we should try to create ties between her and Wisconsin, do supervision here. I think given that she's in custody now, I think she's partially facing consequences for this already. Thank you.
Thank you. Mr. Feliski.
Thank you, Your Honor. I'll first just address the issue of credit again. I have here an amount of 32 days, Ms. Diver being in credit from the time this offense occurred, March 6th of 2026, until being transferred to Minnesota, April 6th of 2026. As the state said, Your Honor, Ms. Diver is not a resident of the area. She does not have ties to the Burnett County community. So probation here isn't necessarily appropriate. She is in custody and is therefore being punished in some aspect for the issues stemming from this case. So I do think that costs and a sentence of time served here are appropriate given the nature of the offense and will be an effective deterrent going forward in order to protect the community. Overall, Your Honor, I do think that this is an appropriate agreement and I would ask the court to follow it. Thank you.
Ms. Diver, do you care to make any statement today?
No.
Okay. This isn't the most serious crimes. You were charged with a felony. However, through the facts whittling themselves down, really a misdemeanor. You're not a threat to the community, at least this community, as far as we know. I think that the agreement is appropriate, so I'm going to adopt it. I'm sentencing you to 32 days of jail, time served, and $200 DNA surcharge per count. I'm waiving the rest of the court costs and fees. If you fail to make the payments and you fail to pay this off, not only will the court enter a civil judgment against you, but the court will issue a warrant and you could sit up to 6 months in jail. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. The jail will make sure that we get that. You have the right to request it be expunged through written letter to the Department of Justice. I am going to order. Do you know when you're going to get out of custody?
No, I was approved for inpatient treatment and I'm just waiting to be released from here to then, and I don't know when that is. My next hearing is June 1st in Pine County.
Okay, I'm going to order $25 a month and I'm going to say that first payment in July. Okay?
Okay.
Give you some time to figure out what you're doing and all of that. Anything further, Mr. Schmidt?
No.
Mr. Feliski?
No, Your Honor.
All right, thank you. Then we are adjourned.
Thank you, Your Honor.
Mr. Kuski, Mr. Riser, can you hear me?
Yes, Your Honor.
Your Honor.
We have to swap out clerks and then we'll be ready to go. We will go on the record in the matter 24 CV 129 Voyager Village Property Owners Association versus Triple S Company. We have, well, I guess we only have Mr. Kuski. You're the only one appearing. I thought we had somebody else appearing, but perhaps we do not. Jonathan Kuski appears as counsel for plaintiffs. No one else appears. Mr. Kuski, you're here. Are you asking? What are you asking?
Yes, Your Honor. This is for the Triple S matter.
Yes.
Oh, I need to grab my other file. I apologize. I grabbed the wrong file for this. I really apologize.
That's okay.
I'll be right back. I apologize, Your Honor. The wrong file got pulled, so I just need to briefly look at this one.
That's okay. Go ahead. Take your time. Well, I have name changes, but you're fine. They can wait just a little bit. This is where there was a confirmation of sale and a check was sent to Voyager Village.
So like something like $870 some left over unclaimed, I think.
Yeah, apparently there's $800 and some left over that's been unclaimed.
Okay, and I'm just I don't think we requested this hearing, Your Honor. Did the court request this hearing? 'Cause I'm not filing a motion on my part for today's hearing.
No, you didn't file a motion. It was just there's extra money and we don't know what to do with it.
Okay, Your Honor. Okay. My understanding from this, Your Honor, is when there's extra money left over following the foreclosure, that the court holds the property. I do see there was a surplus held in the amount of $876.53. That money, I believe, Your Honor, was held in surplus from the sale. Is the Triple S Company, Minnesota Corporation, would be entitled to that, but according to the foreclosure statutes, in order to do that, they would actually need to make a claim to the court to request the release of that money from the court to them. My client, Your Honor, Voyager Village, would not be making any more requests for that money. And I think until Triple S Company takes action, Your Honor, that money would just continue to sit with the court.
Yep, that's my understanding as well. And a notice was sent to Triple S as well. That's who I thought the other attorney, I don't even know if it was an attorney, that Riser person. I thought that they were for Triple S, but I'm guessing they are not. So the court will order that it's held, that we hold it until Triple S Company makes a claim upon it, or it goes through the normal course and it goes to the state, and the state, they have to go that way to retrieve it, which is a far more difficult process. But they did receive notice of today's hearing, so.
Okay.
All right. Thank you, Mr. Kuski.
Yes, and I apologize, Your Honor. We have another one coming up with a motion to confirm a sale, and that's the file that got pulled for me today, so I apologize.
That's totally fine. It's been one of those days.
Thank you, Your Honor.
Thank you.
This courtroom hearing starts off almost casually. Technical problems, attorneys reconnecting to Zoom, and discussions about scheduling witnesses. But underneath all of it is something much bigger. A defendant fighting the system completely on his own. A man representing himself in court challenges the state over evidence in a drunk driving case and even demands that the crime lab analyst appear in person instead of by video. At first, it sounds unrealistic, until the judge realizes he may actually be right. Then the hearing turns into something unexpected. Instead of brushing the defendant aside, the judge starts researching case law in real time, calling state labs directly, trying to schedule expert witnesses, and openly admitting she's never seen this type of motion succeed before. But after reviewing the law, she acknowledges the defendant may have a valid legal argument. And that's what makes this moment so interesting. Someone without a lawyer forcing the court system to slow down and listen carefully. Later in the hearing, another defendant appears by video facing charges for obstructing police and drug paraphernalia possession after allegedly giving officers a fake name while trying to avoid a warrant from another state. But instead of escalating things, both sides work out a plea agreement for time served, recognizing that the defendant is already seeking inpatient treatment and trying to stabilize her life. The judge accepts the agreement, but still gives a warning. Miss payments, ignore court orders, or disappear again, and the court can issue another warrant immediately. Because this hearing quietly shows something most people never think about. Courtrooms aren't just about guilt or innocence. Sometimes they're about whether someone understands the system well enough to protect themselves inside it. So here's the real question. Should people ever try representing themselves in serious court cases? Or is the legal system too complicated to fight without an attorney? Like and subscribe for more real courtroom moments.